and welcome to the Bentsi-Enchill Lecture and Ankoma podcast. I'm Telfer Jnr. and I'm your host. Today I'm joined by Sophia Sena Berdie, who is a senior associate with the Financial Institutions and Capital Markets Group here at the firm. Welcome, Sena.
Thank you, Joel.
And thank you for joining us. In today's podcast, we'll discuss the enforceability of netting arrangements under Ghanaian law. We would specifically look at some of the legislative and regulatory interventions aimed at enhancing the legal framework for enforcing close-out netting arrangements in Ghana. This topic is important because enforceability of netting arrangements is considered an important legal requirement for safe and effective financial markets, and many developed markets have passed significant legislation to ensure the enforceability of such arrangements. And so, Sena would begin. What exactly is netting?
So netting is essentially a mechanism that allows parties to set off their outstanding obligations against each other. So say you owe me 10 cedis and I owe you 8 cedis. Instead of you transferring the 10 cedis to me and me transferring 8 cedis to you, you only have to transfer 2 cedis to me. So netting is an important risk management tool. Instead of waiting to receive a bigger sum, we only have to pay the net amount that is owed to whoever the outstanding obligation is to. Generally, netting is considered as a very important risk management tool in financial markets because two key risks that the financial markets are associated with is market risk and then counterparty risk. Market risk being the risk that is associated with whatever investment you may have made, and then counterparty risk being risks related to maybe a party not paying whatever they are obligated, paying their due under the investment. So simply put, netting allows parties to manage their risk in transactions that they are undertaking. And a key requirement of netting is having a conducive legal framework for ensuring the enforceability of netting provisions.
So just looking at contractual netting arrangements, for example, close-off netting, are these provisions enforceable in Ghana? First of all, what are they? What are such close-out netting provisions, examples of same, and are these provisions enforceable in Ghana?
Okay, so close-out netting is essentially netting that is triggered by the default of one party. So typically it would be insolvency related. So it is netting that is occasioned by a party perhaps becoming insolvent, and as a result, the parties having to terminate the contract. So before termination of the contract, what they will do is they will net off all the obligations they have under the master agreement. So maybe under transaction A, I owe you 10 cedis, you owe me 2 cedis. Under transaction B, you owe me X number, I owe you X number. So close-out netting would typically ensure that we close all the transactions, we net off all the amounts that are outstanding, and then one party pays to the other party what is outstanding. Generally, close-out netting provisions are enforceable under Ghanaian law. However, they are treated differently depending on the type of counterparty that is involved. We have separate regimes for banks and then non-bank entities.
So just to clarify, in terms of enforceability, it's enforceable pre and post insolvency?
Yes, they are enforceable pre and post insolvency. However, the type of counterparty would determine the treatment of that enforceability.
So let's assume it's a regular company that's engaged in the financial markets and they want to engage in a close-out netting arrangement. What is the legal framework or the legal regime that regulates such transactions?
So fortunately, in 2020, Ghana passed the Corporate Insolvency and Restructuring Act, what we will call CIRA for this purpose. And the CIRA made significant legislative inroads into netting enforceability in Ghana. Essentially, what the CIRA does is to say that any netting provisions that you have under qualified financial contracts, which it defines to include the ISDA, the GMRA, the GMSLA, are enforceable in accordance with their terms. And those netting provisions cannot be stayed, delayed, or terminated, or as a result of maybe some action by the liquidator or anything. So generally, under the CIRA, which does not apply to banks and other specialized other entities subject to special legislation, under the CIRA, such provisions, netting provisions, are enforceable in accordance with the terms of those netting agreements. So if, for example, you entered into a GMRA or an ISDA master agreement with a non-bank entity, and there's an event of default, the netting provisions that you have undertaken under that ISDA or GIMRA are enforceable in accordance with their terms. So the parties can net off without any issues under Ghanaian law.
So that would suggest that the appointment of a liquidator or an administrator would do nothing for the contractual netting provisions, and the parties can still proceed to net off their obligations against each other.
Absolutely,
without
under
any
the
difficulty. But CIRA, like you mentioned, CIRA came into force 2021.
Yeah. 2020.
Before the coming into force of CIRA, what happened to such arrangements in Ghana?
That was unfortunate. Before the coming into force of the CIRA, there was no legislative framework for enforcement of netting provisions. So what it meant was that netting provisions or counterparty rights were subject to several risks, including the ability of the liquidator to cherry pick which transactions he wanted or not. So, for example, a liquidator would enforce transactions under which they were in the money. The company that was undergoing insolvency was in the money, i.e. the other counterparty was supposed to pay the insolvent company money. And where the insolvent company was out of the money, the liquidator would say, well, I'm not interested in enforcing this contract, and you would have to wait in line until all the assets are rounded up and then fall in line. So there were significant risks with enforcing netting provisions pre-CIRA. However, what we typically used to do was to advise parties to elect automatic early termination under these international standard contracts. And what automatic early termination does, which is otherwise called AET in the market, is to assume that the event of default, for example, insolvency, happened immediately before. The termination of the contract happened immediately before the insolvency event happened. So if the insolvency event, for example, happened today, what AET does is to assume that the termination event happened yesterday. That's before today when the insolvency event happened. And in such a circumstance, you can enforce your netting provisions. However, AET is not always favorable to the other counterparty, because there could be transactions under the master agreement that the other counterparty was out of money. It wasn't ready to terminate such transactions. But electing AET automatically terminates all the transactions under the master agreement, whether you are ready to terminate them or not. And so it's not really a favorable election. But then to circumvent our law, not circumvent, maybe to overcome the legal hurdle, it was counterparties didn't have any option than to elect AET. So
what that means is that, like you mentioned, CIRA has effectively put away some of these risks, or lowered the risks that come with this type of netting arrangement.
Yeah, CIRA has effectively done away with the requirement to opt for early automatic termination. Essentially, enforceability of netting provisions under the CIRA are guaranteed, and they cannot be stayed or terminated or delayed by any liquidator action.
That's interesting. You did mention earlier that, of course, CIRA is a broad legislation, but it also exempts certain sectors and does not affect those sectors. In terms of banks and specialized deposit-taking institutions, is there a regime for close-out netting arrangements?
Yes, there's a separate regime for close-out for enforceability of netting provisions by banks and specialized deposit-taking institutions. Again, that's the Banks and Specialized Deposit-Taking Institutions Act. We'll call it the BSDI Act for this purpose. However, under the BSDI Act, the type of insolvency event would determine how the treatment would be. So, under the BSDI Act, if the event of default is occasioned by the appointment of an official administrator, you cannot terminate the contract and enforce the netting provision solely by reason of the appointment of an official administrator or any action taken by him. But after the receivership of a bank has commenced, so a receiver is appointed in respect of a bank, which is also an insolvency event under these international standard contracts, the netting provisions under that contract are enforceable in accordance with their terms. The BSDI Act also provides, it uses the term eligible financial contracts. And the Bank of Ghana has defined these eligible financial contracts to include the ISDA, the GIMRA, the GMSLA, and all other international standard contracts related to these matters. And so the BSDI Act guarantees the enforceability of netting provisions. However, the Bank of Ghana reserves the power to appoint a temporary stay on the termination rights under these contracts. But in line with the Financial Stability Board's recommendations for temporary stays, the Bank of Ghana has limited these temporary stays to 2 days. So there's a cap of 2 days. The Bank of Ghana will not impose a temporary stay exceeding 2 days on termination rights. So what it means is that in the absence of a temporary stay, you can go ahead and net off your obligations and close your contract. However, if a temporary stay has been imposed, then you can elect automatic early termination. We've already discussed what automatic termination, early termination means. Then after, which would mean that your termination event happened before the insolvency event happened. The only thing that you have to do is that after the 2 days has passed, you can submit your net termination value to the receiver. You validate it, and then he'll pay you whatever is outstanding.
So Sena, if I'm getting you right, the key difference between the two regimes, i.e. Companies that are subject to sector-specific legislation like banks and the general ones under the CIRA, is that under CIRA, the appointment of an administrator or liquidator will be considered as an event of default,
Yes.
entitling a party to enforce the netting provisions. But under the BSDI, like you mentioned, the appointment of the administrator cannot be the sole reason why the netting provision should be enforced.
Yes.
Is there any basis for this disparity?
Well, I guess it's to provide protection to companies under official administration, but recommendations have been made to the Bank of Ghana to exclude eligible financial contracts such as the ISDA and GMRA from the ambit of this restriction. Okay. So fortunately, if this recommendation is adopted, then eligible financial contracts will not form part of the scope of that restriction. And this is important because it provides certainty to foreign counterparties who want to transact these transactions with Ghanaian counterparties. It gives assurance that Ghana has full netting enforceability without any limitations or restrictions.
That's interesting. What is exactly the risk that title transfer arrangements would be recharacterized as a security pledge and therefore deemed void?
Well, Ghana doesn't have any judicial precedents on recharacterization of these transactions as security pledge. Under the previous jurisdiction, before what we have now, the CSD system operated a pledge system, which had a significant risk of recharacterization. I say that because the Ghanaian courts will typically look to English courts on what to recharacterize as a pledge rather than title transfer. And under English law, these will typically, like a pledge system of settlement, will typically pass as a pledge transaction rather than a title transfer transaction, and will typically fail because the parties don't intend for them to be a pledge transaction, should not have taken the necessary steps to have the security perfected if there's any and stuff like that. But for repos in particular, Ghana has repo guidelines issued by the Bank of Ghana, and the repo guidelines,
repurchase agreements.
Yes, repurchase agreements. Yes, and the guidelines require as a minimum that the documentation under which the transaction is undertaken, the GMRA, for example, provides for an absolute transfer of title. So to be able to undertake a GMRA, a repurchase transaction under Ghanaian law, at the minimum, it must provide for absolute transfer of the securities which are the subject matter of the transaction, including securities for substitution and market-to-market adjustments. And then also for securities that are going to be cleared under the CSD system here in Ghana, maybe local securities, for example, the CSD now operates a free of payment settlement transfer, which means that you can actually transfer your security without money moving in the central securities system. So these two things ensure that your transaction will not be recharacterized as a pledge transaction.
That's interesting. So basically, what are the new developments for netting enforceability in Ghana? What can we look towards in terms of our financial and capital markets?
Well, we've had two interesting developments this year. Essentially the International Capital Markets Association, that's ICMA, and then International Securities Lending Association, both commissioned legal opinions for Ghana. And we are happy to say that we were commissioned to work on these two opinions in August. We've done that. What these legal opinions do is that they provide certainty on the enforceability of netting provisions here in Ghana, which boosts investor confidence in our financial markets. So parties would come to Ghana with the confidence that if they undertake any of these transactions, derivatives or repurchase transactions or securities lending transactions here in Ghana, they are assured that if any event of default happens, they are able to net off their obligations and take whatever their due is without having to go through the liquidation process and waiting several years to get whatever their entitlements are.
All right. Any final thoughts on close-out netting and the future of such arrangements in Ghana?
Well, there's still an outstanding matter, which is the official administration issue under the Banks and Specialized Deposit-Taking Institutions Act. We are looking to the Bank of Ghana to start the process for legislative amendments of the BSDI Act so that can also be dealt with. And this would ensure that Ghana is fully netting positive as is other countries in the developed as is other developed countries. Yeah.
Thank you so much, Sena. It's been an enjoyable discussion. Thank you for joining Bentsi-Enchill Lecture and Ankoma's podcast on enforceability of netting arrangements in Ghana. To read more on such arrangements, search an assessment of the enforceability of netting provisions in Ghana on our website at www.bentsi-enchill.com. See you soon.